Hello, my name is Khyira Sonnabend, and I will be talking about business tort law and what the three main torts are, as well as my main focus is to talk about negligence, but also explain what the other two torts are with it. So what is a tort? A tort is from the French word for wrong, which is a civil wrong or wrongful act, whether intentional or accidental, from injury to others. Also, from the Business Law 5th edition book, a tort is a wrongful act committed by one person against another person or his or her property. So it's not just a physical act against a person where there is an injury, a physical injury towards you, it is also your property that could be damaged as well. There are three main torts. There is intentional torts, negligence, and strict liability. So intentional torts. Intentional torts are commonly found in business areas. This tort also focuses on the protection of the person and their property. The torts may involve interference with the personal freedom of an individual, interference with property rights, interference with economic relations, and wrongful communication. So, to break down what I just explained, interference with personal freedom is assault and battery, false imprisonment, and mental distress. Assault is someone committing a physical act toward you where it ended in an injury. If I were to go and punch someone, that is assault, but it can also qualify as battery as well. Another portion of intentional torts is interference with property rights, which is trespass to land, trespass to chattels, conversion, and a nuisance. If you have land and someone enters your land without your permission, they're trespassing on your property. And also, if they trespass on your property and they commit damages, you can also charge them for that as well. Then the next thing is interference with economic relations, which is experiment, contracts, prospective advantage, and wrongful appropriation. The next one is wrongful communication, which is slander. Slander is the verbal communication that hurts or harms one's appearance or reputation. So if I am talking about my pastor and I am verbally communicating with the news, and I said that he worships the devil on his own time, he cheats on his wife, he rapes people, and none of this is true, this is slander. This is hurting his reputation as a priest, and it is not true. The next thing is libel written defamation, which includes invasion of privacy and fraud. Libel written defamation is something that you have written down in an email or letter of something about someone that will harm their reputation. So the same thing as I just previously stated. If I wrote a letter to the news and said that my priest worship the devil, in church he's preaching about the Lord, but on his own time he is worshiping the devil, he's not faithful to his wife, and he's a rapist, that is written defamation, libel written defamation. This is not true, this is the written form of slander, but it is not true, and it harms his reputation as a priest. Now, negligence. Negligent torts are most prevalent type of tort. Negligent torts are not deliberate actions, but instead present when an individual or entity fails to act as a responsible person to someone who he or she owes a duty to. The negligent action found in this particular tort leads to personal injury or monetary damages. Here you will find most negligent cases in car accidents. It is a very common cases that are brought up. You can be negligent for hitting someone, and I will go over what the different degrees of negligence are and defenses against negligence that will help the defendant as well. So, the elements which constitute a negligent tort are of the following. A person must owe a duty or service to the victim in question. The individual who owes the duty must violate the promise or obligation. An injury then must arise because of the specific violation. So if you are in a car accident and the plaintiff gets hurt, that is from the car accident, then you are negligent for whatever reason you might have hit them. There is some negligent matter in that case. Then, and the injury causes must have been reasonably foreseeable as a result of the person's negligent actions. So if someone is texting and driving and gets in a wreck, there can be foreseeable damages because wrecks are very harmful, and you being negligent, being on your phone, not obeying the rules of the road, that will hurt someone severely. Could hurt someone severely. So there are many different layers of negligence, from due care, which is that people must exercise due care and caution for the safety of others when the risk of injury is present. So just like driving a car, you have to pay attention. If not, you could risk crashing into someone. There is degrees of negligence. That is to define the extent of the risk involved. The three different degrees of negligence are slight negligence, which is failure to exercise great care; ordinary care, which is failure to use ordinary care; and gross negligence, which is failure to exercise even slight care. Also, in negligent torts, there is negligence per se, which is negligence shown through the violation of a statute or ordinance, which brings me back to car accidents. When you get into a car accident, it is most likely to do because the defendant, did not follow the rules of the road, the statutes, ordinances. If he or she was not following the speed limit and they crashed into you, they were negligent per se because they disobeyed the speeding violation, the speed limit. So there are some defenses to negligence, which is one, plaintiff's contribution, which means that the plaintiff was the one in fault for their own injuries, and the defendant will not have to pay any recovery damages for the injury or for the property that was damaged. Sometimes they will look to see if there was comparative fault, to see if it was a 50-50% chance of fault or any percentage in fault for both parties. So they will be looking to see if maybe the plaintiff didn't follow right-of-ways, if they weren't also following the rules and they were part of the wreck, then they will decide what percentage each of them are in fault in and what they will have to pay out. Then there is assumption of risk, which a defendant can use to show the plaintiff voluntarily assume the risk of harm before doing the act that they are performing that day. So if they are charging a minor for hitting them in a wreck and saying that the parents were negligent for leaving the keys and letting them drive, they can use assumption of risk. Many states have gone away with this, but it is still there, so that way you can show that they know that the driver you as a driver went on the road, you were driving, you're assuming the risk that you were driving with unexperienced drivers such as kids who just got their provisional license and do not have years of experience driving a car. Then lastly, strict liability. Strict liability exists when a defendant is in legal jeopardy by virtue of a wrongful act, without any accompanying intent or mental state. Many strict liability extension is to do with product liability. This development imposes strict liability for whatever defect product causes or causes damage or injury. So you see there are many products out in the world that get recalled because of damages, choking hazards that they did not label. Most small toys come with a disclaimer or a warning that not to let little kids play, like under the age of 3 or 4, play with small toys because they're choking hazards, and if they didn't put these warnings, they would be negligent, and there would definitely be damage or injury. So that will sum up my presentation on business law torts. Thank you for your time.